call David Clendon.
Thank you, Mr Speaker. And like others, I'm pleased to be speaking to this bill for the final time in this third reading of the Coroners Amendment. It was feeling that this bill had been around a long time, and I actually looked, and indeed it has been around for quite some time. It was introduced in August 2014, so almost 2 years ago. Acknowledging, of course, there was an election intervened, but the bill's been with us a while, and it'll be good to see it progress and to finally pass in. Having said that, the Greens are supporting this legislation, but I would acknowledge the concerns that have been expressed by the Labor speakers. For us, it was also something of a line call. We fell down on the side of saying, well, this bill does a number of very good things, and for that reason we'll support it. But certainly it's far from complete, and I'm sure we'll have no problem supporting the changes that Labor will make next year when, from government, we're all in a position to do that too. So as part of the purpose of this bill is to streamline, to make more efficient some of the coronial processes and procedures. That's a good thing, clearly. And we hope it will achieve some of that to reduce the workload. But to speak on behalf of the coroners, I do think that the workload will not be sufficiently relieved, and I do think that there is a case to be made to increase the number of coroners and to increase the level of support for those judicial officers. We've had I suppose in a sense it's a privileged position, those of us on the committee who have followed this bill all the way through. We've had a very close first-hand look at the work of the coroners in their office without having to be in the very unfortunate situation of being close to a tragedy or any such, the reason normally people would get to know what the coroners do. So we have discovered, from my view anyway, that the coroners' workload is unreasonable. I've seen their roster and it is brutal. It is a 24/7 call on their time and expertise. It's a very difficult task. It is a judicial role, but nevertheless, they're also required to be grief counsellors and psychologists, as well as being more practitioners of the law. So I do think there's a very strong argument, and we regret the fact that this current budget doesn't actually recognise that and assist the coroners in clearing some of the backlog of cases which does exist. We're told that there's been about a 20% reduction in that backlog. I think that really is not sufficient, and we would like to see more provision made to enable them to do their job even better than they do. They're people of considerable integrity, and I think we should support them better. So one of the more fraught parts of the Select Committee process was entering into the issues around suicides, the reporting of suicides, the provisions of this bill that do deal with that. The AG, the Auditor General's report that just has come out today, notes that in 2013, suicide was the third leading cause of death, premature death in New Zealand after heart disease and lung cancer. And no doubt the numbers have changed marginally in the last few years, but it just highlights the tragedy and the prevalence of suicide in New Zealand, something I'm sure across the House we would all work or seek to redress. Youth suicide in particular, sadly we're seeing more instances of suicides in the rural areas as the reality of the rural downturn kicks in, and for some people they don't see a way out except sadly through that. So I think it's incumbent on us to do everything we can to reduce the incidence of suicide. One of those is around the reporting of it, and I think this bill has come down in the right place. It enables sober and sensible reporting of incidents where it's presumed that a death has been caused by suicide. It doesn't allow anyone without the coroner's approval to say anything about the method or the location where that might indicate what the method was. And I think that's appropriate. The bill puts in place a process where a coroner might allow for an exemption and to allow that detail to be released to the public through the media, but only after there has been a panel established including a person who's with expertise in suicide prevention, a person with expertise in tikanga Māori, a person with expertise in the media and their processes. So I think it creates some fairly robust means to balance out the undoubted commitment we all have to freedom of expression, freedom of speech, but also put some reasonable constraints. We had a fairly robust, dare I call it, submission from an organisation called Media Freedom, speaking on behalf of the media, and the thrust of that submission was that the media should be allowed to report, that it should be left to their discretion, to their good judgment, and frankly, I don't think that that submission got much traction with the members of the committee. There are too many instances where the media undoubtedly would be tempted to overstep the boundaries of good taste, of protecting other people who might be moved to emulate or to sort of copycat suicide. And I think we've found about the right balance. We acknowledge all the arguments about in this day and age of social media, the internet, that sadly some of this information will get out in a way that it ought not to, but we just do what we can do to manage at least the mainstream media, and I do think we've got to a good place with that. I think it's important that we do talk about suicides, suppressing information, conversation in the wider populace, and particularly with the young people who are most vulnerable. Suppressing debate is not the solution. We need to have an informed debate, but a carefully managed debate, a carefully presented debate. I actually went along a couple of, what's the organisation, RATS, the Riders Against Teen Suicide, which is a group of people active in Northland. And I must acknowledge Hone Harawira, who, my apologies, Arthur Harawira, who suffered the ultimate tragedy as a parent of losing a son to suicide, and yet is still able and strong enough to stand in front of audiences of young people talking about what the cost to his family was and to him personally of losing that young man. And I think that's an admirable formula, if you like, the context is such that we can address young people and explain to them why they ought never to consider that that is a choice they should ever make. But it needs to be a very careful, managed and structured conversation, and the media is not the place to do that. So one of our initial objections to this bill was that the current situation where deaths in custody, particularly deaths in prisons, must trigger a full inquest. That's mandatory. There is now discretion for the coroners to choose in some instances not to undertake a full inquest. There must still be an inquiry, but not a full inquest, and we think that balance is about right. I've personally been persuaded by personal conversations with coroners, with the submission from the Chief Coroner, that said in this present-day reality of more people getting older in our prisons, there are situations where deaths in prisons are entirely predictable given health, the ill health of inmates and the like. So I do think that that we can put a level of trust in the coroners to make those calls. Personally, I don't have confidence in the culture of the Corrections Department to be transparent, to be open and honest about deaths in custody. So the current language, or the new language of the bill as it's now presented in its final form, talking about deaths with the medically unexpected, or where a medical officer would not have expected a person to pass away based on their previous history, the medical notes and the like. I think we've hit a good spot with that. Obviously, it's something we'll need to continue to monitor, but for the moment we are relaxed, or at least we think that is adequate protection to ensure that there is a very rigorous application of inquiry and, if necessary, inquest where deaths do occur in custody. Because there have been too many examples, sadly, where people have died in custody and prison, and it has been a result of negligence, inadequate health care, inadequate monitoring. Preventable deaths have occurred in custody. We've got to be very sure where they do occur, that there is a spotlight shone on them, and that we seek to ensure that those circumstances don't reoccur. So the final point I'd like to make, the new bill puts in place some provisions in situations where a body is returned to the family, but where some body parts or samples are retained by the coroner or the pathologist more accurately, there is provision, it's a requirement effectively that families need to be informed of that and that they can request that those parts be returned to them at the appropriate time. That's important, not least of all to Māoridom, but to people more generally. So with those few comments, we do continue to support this bill.